This Lordship, I beg to mention item number 11, Lordship. And for respondent number 327.
You're for respondent?
Respondent number 327. I have informed the other respondent also.
On pre-made by the respondent, 327. Not objected to by petitioner. Matters adjourned. This is the same after 2 weeks.
Yep. Lordship, I beg to mention item number 8 of the main list, Lordship. Lordship, learned senior counsel has some personal difficulty. Lordship, I'm praying if this matter can come up after next 2 weeks, Lordship. 8, Lordship. 8, main list.
1, 2.
I have informed the respondent, Lordship.
Petitioner.
Lordship, petitioner.
On pre-made by the petitioner. Not objected to by petitioner by respondent. This is matter after 2 weeks.
I'll oblige you, Lordship.
On daily list, item number 1.
Lordship, conducting counsel Mr. SN is on his legs in a hearing matter. I humbly pray that this may be taken up after 2 weeks, my lord. After 2 weeks, my lord.
On pre-made by the petitioner. This is matter after 2 weeks.
Item number 2.
Lordship, I'm praying for another 1 week time, Lordship. The draft is ready. We're just awaiting signature from the parties.
All the respondents have filed their counter.
Yes, Lordship.
Yes.
Miss Learned Counsel for the petitioner has sought for some more time to file the rejoinder to the counter affidavit filed by the respondents. Pray aloud. This is matter after 2 weeks.
Item number 3.
Lordship, item number 3 is connected to the first matter.
Same order.
Highly obliged.
Item number 4.
Lordship, we'll be filing a rejoinder today. I have a small prayer, my lord, if the matter can be listed for hearing on 20th of June.
Why?
Why, Lordship? If Lordship is pleased to see the affidavit filed by MPSC, it's on board. They have said that the matter is connected to.
Yes.
If Lordship will kindly see the affidavit filed by MPSC, respondent 2.
Page?
Lordship, page 5, paragraph 20.
Page 5?
Page 5 of the affidavit. Affidavit filed by respondent number 2, Lordship. Affidavit in opposition filed by respondent number 2. I believe it's dated 21st May 24, Lordship.
Just one. Respondent number 2.
Lordship, respondent number 2. It's filed by one Shri Ashish M. Sangma.
Page 5.
Page 5, Lordship. Paragraph number 20.
Yes.
Lordship, the amendment made in paragraph so and so of the petition answers and respondent states that the commission is abiding by the order dated so and so passed by this honorable court in WPC 466 of 2021. So they are saying it's connected. Our plea is that it is not connected. This is the issue, my lord, where there are two advertisements, one for direct recruitment, one for promotion. and the result was never declared since.
Transport inspector matter?
Yes, Lordship.
Your Lordship, there's an interim stay, Your Lordship,
In 466.
regarding in 466, where the selection process, which culminates from the same advertisement, is being stayed by this court.
But
And
here the
petitioners in this case, they were the participants of the said advertisement. So, because of the stay, the MPSC cannot declare the results as the order
So
specifically.
what's your case then?
No, here what has happened, after filing of our writ petition, the government has come up with a letter saying that the advertisement which we are claiming has nothing to do with the advertisement which is subject matter of the matter pending before this court. That is the affidavit filed by the state respondents. MPC is taking a different view, Lordship.
Your Lordship, there were two advertisements. One is 4 posts, and the second advertisement,
Or advertisement?
two advertisements. And then second advertisement is of 2 posts, which were advertised by us. And then after, Your Lordship, a letter came from the state government which says that the second advertisement to be cancelled.
Okay.
So the
Cancel
selection.
because there was a rethink on the number of vacancies.
Yes. So the original advertisement, they have clearly said in the affidavit of the government that that does not have anything to do with the pending court case. So which is why I'm praying, my lord, that
You participated in the first.
in the first advertisement in 2017.
That is for the 4 posts.
4 posts, Lordship.
Now you're aggrieved by the
Non-declaration. No. What has happened, Lordship?
non-declaration.
Yes. 2017, there was an advertisement for 4 posts.
So they are saying that because of the issuance of the advertisement as far as 2 posts are concerned,
Yes.
so the matter has been stalled.
If I may just explain, 2017 there were 4 posts which were advertised to be filled up by direct recruitment.
Yes.
In 2020, another advertisement was issued to add another 2 posts to the same process. But the recruitment process were carried out in two different tranches.
Yes.
Now, for WPC 466 of 2021, which was filed before this honorable court, basically is on the premise that if 6 posts are filled up, the reservation for 33% and 67% will be affected. And an order has been passed that the outcome of the selection process would be subject matter of the proceeding of the writ. Now, we came with the first round of writ petition, Lordship, seeking for a clarification as to whether the original advertisement of 2017 would has also been kept in abeyance. The government, this honorable court directed the government to reply to our representation so as to clear out the picture. In pursuance thereof, they have issued a letter saying that the 2017 advertisement stands, it does not attract any court case, and the 2020 advertisement by which 2 further posts had been advertised has been cancelled. So that is the position, my lord. So in our submission, the 2017 advertisement results may be declared. So we will be filing a rejoinder to the affidavit.
Because of the subsequent cancellation of the.
Yes.
But
So
now they're maintaining that it has not been cancelled.
No, Your Lordship, because this
they are
order,
MPSC,
this
they cannot go beyond the government's.
this order of 17/12/2021, which was passed in WPC 466 of 21, specifically states to keep the selection process on hold. So,
Okay,
the selection process is already done. We are waiting only for the results.
What is the status of this 466 then?
Now in 466, they have filed a connected petition before the Supreme Court, challenging one of the orders passed by the division bench of this honorable court. And in view of that, they have made a submission here that the matter is pending before the Supreme Court. So it has been adjourned sine die, Lordship.
Yes, but see, if this government met in paragraph 20,
Lordship.
so this is an extract of the order.
Yes.
So it says that the selection process is not to be published.
Lordship.
So what do we do?
If Lordship is pleased to have the affidavit filed by the state respondent, Lordship, that will clear out the.
Make this is Lordship. Let the matter be heard, Your Lordship. Let the matter be fixed for hearing.
Let it be on 20th along with 466. Then it can be cleared. Lordship.
Is before this court.
Yes.
Well then.
Let the matter be heard. Your
In the meantime, I'll be filing my rejoinder today itself.
Mr. Letter counsel for the petitioner has submitted that the rejoinder to the affidavit, counter affidavit filed by all the respondents,
No, only respondent 2, Lordship.
by the respondent 2, has been may be allowed to be filed in course of the day. In the meantime, it is prayed that this matter may be posted for hearing. As prayed for, this is matter for hearing on 20th.
20th, Lordship. 466 is coming on 20th.
Yeah, 20th. Sorry. I may say 20, I may say 20th.
Lordship,
It's understood.
Lordship.
Highly obliged.
Much obliged, Lordship.
Item number 5.
May it please your Lordship. Your Lordship, as per the directions of this Honorable Court, we have taken steps on respondent 1 to 3, and the service report is awaited, your Lordship, in this case.
Item number 5 and 6 are similar matters.
Just a moment.
I'm for item number 6.
I think there was a query made by this court. See, in case of a transfer matter, so the court below would refer the matter to the High Court,
Yes.
and the records would be, sent to the, which is not important. So now this court would proceed, on this on the basis of the same case records, or would there be, separate application or petition by the?
No, there's a reference made by the trial court. On the basis of the reference, will automatically transfer to any other courts.
True, reference. I'm questioning rather I'm inquiring about the form and the form and the format. Where is the order of reference?
Order is on 10th April 2024 that has been passed by the learned trial court in the reference matter to refer the suit before this Honorable Court. Last one.
Be in the order sheet.
Separate order sheet in the last file, your Lordship. Yeah, that's the one passed on 10th April, your Lordship.
Where is the order?
It's here, your Lordship's in this one.
Who is the lawyer or the lawyers who had appeared for the parties?
I am for the appellant before the trial court.
I'm for the respondent number 4 and 5, my lord.
Respondent 4 and 5 and?
Actually, respondent number 1, 2, and 3. Respondent number 1 is the Dorbar of the office of the same of Iman Ahmed. 2 and 3 are the.
Where's the cause title here?
Post title is in MCA case number 8 of 2022, your Lordships.
8.
Yes, Lordships, that is an appeal.
So 1, 2, 3, 4 and 5 are the appellant.
Yes, my lord. Appellant.
So you are appealing for?
No, I'm appealing for the respondent number 4 and 5. I'm for this.
Respondents are, number 1 is the Dorbar of Langren.
Yes, your Lordship.
Number 2 is Westerly Kharsao. Number 3 is Ms. Donat Lingdo.
Number
4 is Lenistis Imyong and
is models. 5 is
so
S
you're
model.
4 and 5.
4 and 5, my lord.
Now, 1, 2, and 3, you are appearing for Mr. Sawan?
For the petition in the next matter, item number 6.
Not
No one is representing respondent 1, 2, 3 till date, my lord.
No one.
No, they are yet to take steps.
Service report is awaited, Your Lordship. We've already taken
Or
steps.
even before the trial court,
Yes,
before the appellate court, first appellate court. Before the first appellate court, you are the
I'm for the
appellant.
appellant. Yes, Lordship.
so at that point in time you have taken steps.
Taken steps, Your Lordship.
But you should have waited for all the parties to be present before, before making your prayer before the court for transfer. That order would have been passed in when all the parties are in before the court.
No submission. In fact, before the another trial court, all the parties are represented. Subsequently, due to the suspension of the respondent number 1, all of the Lordship recollect. Nothing same young.
Yes.
Still pending before the division bench. An appeal of now in his absence, we have taken steps on to the office of the Darbar Same.
Okay.
Upon the acting same.
On the acting. You have taken steps.
Your Lordship.
You are who's you?
Both of us we have
Oh,
taken
you are in
steps.
the other case. Okay, let's not get confused with that.
I'm in transfer petition number 3, Your Lordship.
Yes. Who was appearing? You are appearing for the appellant. Then you could have informed them that this matter is pending for the court. That is as far as the respondent number 1 is concerned. If you are appearing for the respondent number 1, then you could have.
He's in transfer petition number 4, Your Lordship. I'm in 3.
We're talking about transfer petition number 3.
Your Lordship.
In 3, you are the appellant.
Your Lordship.
He said he's representing the respondent number 1.
No.
You're not.
There's a confusion. Let my friend give a submission. I'll come to the next matter.
In respondent number 2, that the headman was expired, Your Lordships. So that has to be substituted. We have taken the steps. Giving notice to the Darbashna, which is pending, Your Lordships. 4 and 5 is appearing. 1, 2, 3. We have taken a step that is awaited, Your Lordship.
I think I'll refer back this matter to the appellate court. Let all the formalities be completed there. Because if you have to take steps for substitution, if they have to come, let them appear before the first appellate court. Matter to be settled there. When all the parties are present, have acknowledged their attendance, then prayer can be made for the transfer, and the court can. In fact, the court can elicit the response of the concerned parties, and with that, a reference can be made to. Because now, you see, this you have made this court, you see, as one of the I don't know, not as an appellate court, not as an original court, because now the process of substitution has to be affected here. Because how can you affect notice then? And without presence of the parties, the court cannot pass an effective order.
The difficulty is none of the judges or the can take up the matter. That's why we have prayed for referring the matter to some court. So this matter can be transferred to any other court.
So now only, Mr. Shila, you are appearing for only for the
Respondent number 4 and 5. Yes, ma'am.
You have no objection to the transfer.
Yes, but the only thing is that to which forum that this particular appeal is going to transfer. I think that's the only aspect that needs to be discussed.
So it goes to the judge.
No.
If we suppose we transfer the matter, at most we can transfer it to
Another district council.
Genti Hills.
Yes, madam. Yes.
We have no objections to that.
Yes, madam. And so far that aspect is concerned, I don't think so we are having any objection.
You may not have, but
Yes.
we are still concerned about the other three.
Yes, yes.
What if they don't agree or they submit? Anyway, that would be academic, no doubt.
And that has to be decided by the Honorable Court, this, if they have any objections to it, Your Lordship. If the reason is, the reason cited in the application is reasonable, then this Honorable Court has the power to transfer the matter.
Fine, fine. I think you. Mr. S. Roy, Learned Counsel for the appellant before the court of the judge, District Council Court. Hills, Shillong, has submitted that the notice issued upon the respondents number 1, 2 and 3 could not be affected. Mr. Jeshalal and the counsel for the respondent 4 and 5 has, however, present in court today. The Learned Counsel has reiterated that the appeal pending before the court of the Learned Judge, District Council Court, Shillong, could not proceed on the ground that the said court, on the ground that the presiding officer of the said court has dealt with the matter in what capacity?
As presiding officer.
As presiding officer of the subordinate District Council Court, Hasil Shillong. Similarly, is it the judge or the additional judges?
So the appeal is before additional judge, Your Lordship.
Additional judge. Similarly, another additional judge of the District Council Court is also unable to take up the matter. On the same ground that the court had, that the presiding officer of the court had handled the matter as the presiding officer of the subordinate District Council Court, Kasihil Shillong. The Learned Counsel for the petitioner has for the appellant has therefore prayed that in such a situation it would be appropriate for this matter to be transferred to any other court of competent jurisdiction, and the parties may be and steps would be taken for all the parties to be present before such court. Without going to the merits of the case and taking due note of the reference placed before this court, wherein the Judge, District Council Court, as indicated the inability of the said court, that is the courts of the additional district judges, District Council Court Shillong, District Council Court Khasi Hills Shillong, to take up the matter. The parties in attendance before this court has agreed that the matter could be transferred to the court of the judge, District Council Court, Juai or Jainti Hills?
Joy, my lord.
Juai. Accordingly, the prayers allowed the said appeal number
MCA number 8 of 2022.
MCA number 8 of 2022
2022, my lord.
pending in the court of the judge, District Council Court Shillong, is now transferred to the court of the judge, District Council Court Joai, West Jainti Hills District. With the direction that the said court would take up the matter, and on appearance of the parties to dispose of the same in accordance with law. The records transmitted to this court are hereby sent to the court of the judge, District Council Court Juai, for necessary action. Anything else?
No, my lord.
This is dispose of.
The next matter, my lord, the only thing will change is the case number.
Same.
Same order. Case number MCA will be
You will-
MCA
you will
number
be the
1.
appellant there.
I'm there.
Okay, next
MCA
case.
number 1 of 2023.
Ang taka kerteng yung tu appellant I know sisi di sama.
Blush, my lord.
Item number 7.
Yes. Yes, Mr. Linja. Then.
Will please, Your Lordship, the Contempt Council is on next, my lord, Mr. SN.
This
So this is that issue
711
regarding 7 to 11.
rejection of plea.
What do we do?
It'll come after 1 week, my lord.
There was a, I think earlier there was
Other
a,
matter that is under
there was an
section
order,
94A.
there was an order passed as far as maintainability is concerned.
That is in the other matter, Lordship. That concerns section 94E of CPC.
Okay. So which matter ought to be,
This
decided
should be heard first, Lordship.
This ought to be.
Lordship.
So if this matter is decided, then it will have a bearing.
If your Lordship rejects this application, then the entire suit
Okay.
goes.
When do we have it?
After 2 weeks, then, Lordship.
On premiere by the parties, this is matter for 2 weeks.
Highly objected.
Item number 10.
This list.
Who's respondent 4?
Respondent 4? Yes.
You are respondent 4. So you have not issued or rather supply a copy of the affidavit to the.
They've given us, my lord, a copy of the affidavit as per the last request that I have made, my lord. They have given.
So we'll continue with the hearing then.
You are ready, sir?
Yes.
Okay.
Yes, Mr. Hari.
May I please, your lordships? Brief fact is that, my lord, that one late Sana Sangma and Jimra Sangma late purchased a land from Jinan Nokma of Rongring Bri.
This microphone is working or not?
Purchased a plot of land for rupees 800 on 8 January 1918.
Yes.
It is page numbers.
26.
Yes, 26, my lord. Shall I read out, my lord? In the court of Deputy Commissioner, Garo Hill District, Petitioner Jenang Nokma, Rongreng Bri, E. Angjing L District, Garo Hills, my lord. We have filed an application to the DC, where he is mentioned that I have sold the following western portion of my village, Rongbing located in the Elaka of Sangjing Loskor to Sana Nokma and Jimra Nokma of village Rongreng as per the boundaries shown below in the presence of the Harnath Marak Mojedar and the Thanjing Loskor, and also in the presence of other Nokma belonging to contiguous king surrounding mine, my lord. So he has purchased the land by two persons, Sana and Jimra, my lord. And after buying this one, my lord, I am coming to the GT, my lord. GT page number. It is in page number 44, my lord. Type copy is 45, my lord. In the number 5, my lord, it is GT.
Yes.
The inaugurality of the Nokmas. Then my name was recorded as a Nokma.
This is the GT.
Yes, and my wife Jafran Marak Misi, my lord. After buying this land, my lord.
Yes.
Then I come to page number annexer 2, my lord. Type copy annexer page number 29, my lord. Thereafter, he is praying for this extending the boundaries of the purchased land, my lord. It is on 8 January 1918, my lord. Dated is, they have done it 9 January 1918, my lord.
1918.
Yes, my lord. 9 January 1918.
Just inject, my lord. As my lord is very much aware,
No,
my lord.
I pray that, my lord, in my argument, later on, let me say any other
Let
thing.
me just point out, my lord. I have every right to point out, my lord. It is his case, my lord. He is the master of his case. But, my lord, here there is a concurrent finding of two courts, my lord, EM court and CM court. The CM has upheld the EM's order. And there was an order of this honorable court, my lord, by order dated 8/3/2018, my lord. Now, my lord, my learned senior, I'm no one to teach him, my lord, but I'm just pointing out, my lord, whether the order of the Honorable High Court was not complied with by the EM or CM, he has to point out, and whether the procedure has not been followed. That is the only thing, my lord. My lord cannot go, my lord, who has purchased land from whom. This is an reappreciation of evidence, my lord. That is not permissible, my lord, under 226, my lord. Now, my lord,
What he's trying to, to
Yes.
present
my lord.
Is the facts of the case, the background of the case.
But even if we go into the merit, my lord, like who has purchased
that,
from
of course, that is a different thing. I think this court has made it very clear.
Merit, it will
we
come
cannot,
later
we cannot
on.
go into the merit.
Yes, exactly, my lord.
Cannot appreciate evidence.
Yes, my lord. Yes,
Only
that is
thing
what,
is
my lord.
at this stage, what the court would have
No,
what the court would have to look
Yes, my
is if there's any anomaly in the procedure
Yes, exactly, my lord.
or the process,
Yes.
carried out.
Yes,
That is the only thing.
yes.
Your Lordship, let him just read out the impugned order so that the facts also.
No, my lord. Impugned order directly going, it will be, for me, it will be something, it is very difficult to understand, my lord. Because we have purchased it, they are telling, they are purchased it. That is the thing.
That is again matter of evidence.
No, it will come. Matter of evidence, though, it will come, no. Please wait, your term will come, you will say whatever you like.
What you see, Mr.
No,
Mr. Hajira,
my lord, at
but
the
is
time-
all, you see, Mr. Hajira, it's also incumbent upon you.
Yes,
When you state your case,
Yes.
you have to be brief.
yes,
Huh.
yes, I will list.
A long-winded argument would not help anybody.
Yes, my lord. I will state this fact. After that, I will
Straightforward,
come
he
to.
should go to the 3 points only, that High Court has passed this order, EM has passed this order, CM has passed this order. These orders are not in accordance with the High Court's ruling. That's all, my lord. He has to point out why he is taking, my lord, who is purchasing from whom.
No.
But you have
What-
to, yes,
no,
just
no.
briefly
what-
say, briefly.
No, my lord. Why it is coming like that? Because they come into the picture after a lapse of 75 years. They are not the Nokma for 75 years. In 1996 only. That is the reason I have to.
Have you pointed this out before the EM or the CM?
Yes, they have.
No, that is not a ground.
Yes.
Let us see his appeal, my lord.
No. That is.
Let us see his appeal.
Fine. Let me.
Yes. Let me finish. Let them shout whatever they like.
Will not shout, will not.
Yes. Because that is their habit, my lord. When I am making argument in the middle, they are saying. That is disturbing for me, my lord.
Yes.
I don't want. When their term will come, let them say anything what they like. I will keep quiet. Thereafter, my lord, then boundary pillar was erected in page number 31 of the purchase land, my lord. Then again from the tail pages maintained by the district council, my lord. Thereafter and come to another page, my lord, annexure 5.
Page.
Page number 40, my lord. Then type copy will be page number 43, my lord.
I think all these submissions you have advanced earlier.
It is required, my lord, because I am become the Nukma.
The earlier, the last time when this matter was heard,
Submitted.
you have submitted all these.
Yes, I have submitted, my lord.
No need to repeat.
He was in on
and-
the order which has been enclosed by my friend. He was on that, my lord.
Oh,
Ah,
I think you have not enclosed that.
Enclosed, exactly, my lord.
You have referred to his affidavit, isn't it?
Yes. Now the affidavit is there, my lord. He can read the affidavit, my lord.
Now, I am coming. Then the EM, after passing this one in 1996, my lord. 1996.
Page.
1996, my lord. Then Nerzing Arshangma, respondent number 4.
Page number.
It is here, my lord. The copy is here.
Oh, it's not in your pleadings.
Yes, my lord. That is that is in the this respondent. No. Wait. That is in the affidavit in opposition. Annexure 7, I think, my lord.
Next year.
Annexure 7, page number 67, my lord. In their affidavit in opposition, filed by the respondent number 4.
Respondent number 4.
Yes, my lord. Pass an impugn order. That is also impugn order, my lord. Dated 22nd August 1997.
Page 67.
Yes, my lord.
22/8/1997.
Yes. Yes. 22/8/1997, my lord.
Yes.
That here, my lord, this is, they have passed the order, ex parte order, without my presence, my lords. And last paragraph, since there is no objector among the Rangmutu Mahari either in the time of Mojedar, ongoing or in my court, I hereby order that the name of Sri Withing Marak and his wife Srimati Nerangin Shangma be recorded as successor Nokma in place of late Robert Marak and his wife Eve Enezeting Shangma in respect of Rongrangri Ak England, correct the GT, my lord. We agree by this order. After agreeing by this order, we will file an appeal. In appeal also upheld the order of EM. Thereafter, we went to come to the High Court, my lord. It is in page number 46, Annex 7, my lord.
Page number?
Page number 46.
40?
46. Yes, 46.
Annexure 7.
Yes, minute. Then I read out from 48, my lord, page number para 5, my lord. Para 5.
Para 5.
Yes, my lord. Para 5, I am reading, my lord. Mr. Jindal, learned counsel for the petitioner, argued that the executive member passed the order ex parte without affording any opportunity of the petitioner to submit their case, and on improper appreciation of the fact, relying upon a recommendation made by the local MDC, Sri T. Marak, which is not permissible in law. Mr. Jindal further submitted that the order dated 22nd August 1997 was passed on extraneous consideration, such as the report of MDC, and without framing any issues, and without giving an opportunity to the writ petitioner to adduce evidence in support of their objection. That apart, the executive member are also called upon the document filed on behalf of the respondent number 1 without any scrutiny and verification, though the said document were not genuine. According to Mr. Jindal, the executive member also erred in relying upon the inquiry report dated nil submitted by the Mojadar, next page, my lord, of number 4, which was based on the inspection dated 15/10/1997. The said report could not be there on record, as impugned order was passed on the basis of this Alice Mojadar report. Number 6, my lord.
Yes.
Then I come to para 8, my lord, that only this operative part. Page number 49. It is crystal clear from the order dated 22 August 1997 passed by the executive member that he had not only taken into consideration the report submitted by the MDC T. Marak, but also inquiry report submitted by Mojadar. There is no detailed discussion with regard to recommendation of the MDC and the inquiry report of the Mojadar. It is also not clear whether the copy of the recommendation and the report, next page, my lord, were furnished to the writ petitioner with opportunity to submit their objection. The learned executive member, apart from these two reports, have gone through other records such as Warang map, etc. In my considered opinion, the decision rendered by the executive member on the basis of the document without appreciation of other evidence, if any, on record, and also without affording due opportunity to the parties concerned to the adduced evidence cannot be sustained in law. The report submitted by the Mojadar after spot verification on 15/10/1997 could not be document available before the executive member at the time of passing the order dated on 22nd August 1997. It is evident from the report appended with the writ petition as Annexure 8 This shows that the executive member did not apply his mind at the time of passing the impugned order. The appellate authority, that is chief executive member, in his cryptic judgment was reiterated the observation of the executive member without entering into depth scrutiny of the document and other material available on record. For reason above, the court is unable to sustain the impugned order dated 22nd 8 1997 and 23rd September 2003 passed by the executive member in charge land revenue Garohil Autonomous District Council chief executive member Tura respectively. Hence the writ petition is allowed, the aforesaid two orders are set aside and the matter remitted back to the executive member for decision afresh after giving due opportunity to both the parties to adduce evidence and to make oral or documentary submission till the matter is finally decided by the authorities below. Status quo in respect of the concerned action as on today shall be maintained, my lord. Thereafter, matter was remanded back to district council, my lord. Then district council passed an order in my favor in Annexure 8, my lord. Type copy is
Page 69.
Type copy is page number 70, my lord.
70.
Oh, 69. We start from 69, my lord.
Yes. So this is the judgment on order dated
Yes,
23/7.
yes, in my favor, my lord. I will go to the operative pub in the page number 73, last paragraph, my lord.
Yes.
Here, my lord, this is the operative part, page number 70, last paragraph.
Yes.
All the documents submitted by the opposite party are dated and signed by the concerned parties to the sale and finally approved by then Deputy Commissioner carry good amount of credibility and all executed between 8 January 1918 to 2nd February 1918. These documents were never challenged by the petitioner, that is respondent number 4 here, except the denial of late Jimra Sangma as co-purchase with the late Sana Sangma. Instead, the petitioner claimed that the Rongrengri Aking was purchased by late Sana Sangma and late Kaman Mara. Also, next paragraph, my lord. Produce map dated 1925 in which both the name of the Sana Sangma and late Khanam Marak have been entered as co-nokmas. The petitioner also produced Mojeda report Alice prepared on J.B. David in the year 1927, in which Mojeda stated the Akhin map had been prepared in the year 1925, even before demarcation of the Akhin boundary in 1927. Hence,
These orders are all set aside by the High Court, my lord. This order.
I am coming.
Yes, my lord.
I am coming. Please don't become impatient. Please sit down a little bit. Huh? Hence, it is difficult to believe the same. Moreover, there has been already a demarcation of the Aking boundary on 21st January 1918, my lord, by the competent Mojadar on direction by the authority in favor of Sana Sangma and Jimra Sangma, my lord. That is important, my lord. Hence, there is no necessary to prepare another map in 1927, which is 9 years later as claimed by the petitioner. In view of the above discussion and finding, I decline to accept the petition filed by the petitioner Srimati Nerenjing Arsangma, that is respondent number 4. Hence, her petition is rejected, and the opposite party, Sri Aban Momin and his wife, Srimati Justina Armarak, who were already recorded Nokma Rongrengri, and Aking is allowed to continue Nokma. In the result, the petition is finally disposed of. I pass no order. It is passed in my favor. Then, against this order, my lord, they have made an appeal before the court of CM, Chief Executive Members, my lord. Then Chief Executive Member passed an impugned order, my lord. It is Annex 10. Type copy is 81, page number 81, my lord.
Yes.
Passed on 19/12/2013, my lord.
This order is also been set aside by the High Court, my lord.
No, yes, I will come.
This order also, what is pointing out, has been set
I
aside.
will say,
Okay,
don't take
just
levers.
in one word.
Yes, yeah, also set aside.
No, the order of the CM has upheld the order of EM.
No, my lord. It's reverse.
It is reverses.
And both
Against
the
this order, we have come to the High Court.
High Court has set aside both the order,
High
remanded
Court
it back, my
has-
lord. And how it is relevant, my lord? Whether those evidence
No.
or the finding. Let me just complete.
No,
please.
no.
No, let
me
me.
finish first,
Just,
no.
I
me
see.
finish.
I understand.
My lord, the finding of the EM and CM, once the High Court set aside, my lord, the order,
Yes.
how it is relevant, my lord?
You have filed the petition before High Court.
Yes, my lord.
Then
And High Court set aside those order, both the orders, my lord.
What is the tell me
yes.
relevant order of the High Court?
High Court is Annex 11, page number 85.
8/3 to 2018, my lord. Order dated 8/3/2018.
Yes.
This is by this order, my lord. If my lord may kindly come to the page 89.
Mr.
My lord, yes, ma'am. Because I find, my lord, these are not relevant because High Court has set aside and my lord is not sitting in review, my lord.
Exactly, but let
No,
me.
no.
Yeah.
But it is correlated.
understand
my lord.
the-
Yes.
the-
Otherwise,
the
there
subject
will
matter.
be no argument at all. And moreover, he will not become impatient. So that is one another reason. Page number 89, my lord. I am going the operative part, my lord.
Yes.
After hearing the submission advanced by the learned counsel for the parties and considering the fact and circumstances of the case, I am of the view that the matter cannot move and travel from court to another court. Otherwise, there will be no end of the litigation. However, in this case, considering the principle of equity, I am giving some more chances to the.
One more chance, not some more. One more. Yes.
Thank you.
So you read properly.
Yes, my lord. I am giving one more chances to the learned counsel for the respondent number 1 to cross-examine the petitioner's witnesses. Both the CM and the EM are hereby directed to see that the matter should be disposed of within a month from the date of receipt of the copy of the judgment and order. Similarly, the CM is also directed that if at all any appeal is filed before him, that also to be decided within a month from the date of filing of the appeal. Accordingly, I hereby set aside the impugned order dated 19/12/2013 passed by the learned Chief Executive Member GSADC, my lord. Only their order. My order is not cancelled.
No, my lord, it is March.
No, anyway, wait. Then they pass. Then the matter is referred to the Chief Executive Members. Has also passed an impugned order, my lord. In page Annex 12, page number 90, my lord. Impugned order passed on 17 December 2019, my lord.
This is passed by EM or CM?
EM, my lord.
EM, my lord.
Yeah.
Yes.
I read it, my lord, not much, and going to finish also. Order. This joint Nokmaship cases referred by the Honorable High Court of the Meghalaya on 8/3/2018 in WPC number 26 of 2014, directing this court to cross-examine the petitioner witnesses. Upon direction, this court complied with the order of the Honorable High Court and heard both the side in detail accordingly. On perusal of the record available on the office and also deposition of the witnesses, this court observed as indicated hereinafter. It will also clearly indicate that the Shana Shangma paid rupees 400 and Khanam Nokma paid rupees 400 each to the Jingnang Nokma of Rongrengri White Sasansas in presence of 14 witnesses reported by J.M. David, Mojadar 14, which was approved by then Deputy Commissioner G.D. Walker, Garo Hills on 12/12/1927-28 accordingly. The GT in respect of Rangmuthu clan was prepared on 15 March 1927 and duly approved by then the Deputy Commissioner, declaring Khanam Marak, Miasha and Anezing Shangma Misik were the first registered Nokma of Rongrengri Aking from Rangmuthu clan. The present petitioner, Srimati Narenjing Shangma, along with her husband, was recognized as Nokma of Rongrengri, Rongrengri 45610 Aking on 22nd August 1997. That is most important, my lord. Is still continuing the same post of Nokmaship representing the Rangmuthu clan. It is therefore held that both the parties named above mentioned as a joint Nokma of Rongrengri Aking, since the Aking jointly belong to Raksham and Rangmuthu clan as recorded, and hence the Nokma of Rongrengri Srimati Narenjing Arshangma, who represent the Rangmuthu clan, to be continued as Nokma of Rongrengri Aking. More so, there was earlier decision by the executive member IC, Revenue, and also the chief executive members GSADC Tura, who rightly took notice of the document regarding the sale and boundary of demarcation of Rongrengri Aking, my lord. Here, my lord, what happened? This one they are claiming after a lapse of 75 years, my lord. Before that, they are not the Nokma of Rongrengri Aking. No, only 97 it is come to the pictures. And what are my sale date from the beginning? It has not been challenged by the respondent authority. Next, my lord. The GT in respect of Raksham and Rangmati clan is very clear on record as on today, which shows different and separate ambi for both Raksham and Rangmati clan respectively, and cannot be denied at the juncture, which clearly concluded the contention of the parties accordingly. Hence, the Rongrengri Aking will be continued by the joint Nokma from the Raksham and one from the Rangmuthu, representing the respective clan as was before. The case of Nokmaship and Narenjiri Amri will continue as it is, as the documentary evidence on record has clearly and particularly indicated separate ambi for each clan. Therefore, the daughter of Narenjiri Arshangma and Srimati Menoritha Arshangma is entitled to appoint as Nokma of Rongrengri Aking, representing Rangmuthu clan by right of inheritance under Garo customary law of inheritance. And also it clearly indicates that the present petitioner Srimati Narenjing Arshangma and her daughter Srimati Menoritha Arshangma finally concluded the contention of Nokmaship as documentary evidence corroborated and supported right from the time of the British regime. In view of the above matter, this court ordered that Srimati Narenjing Arshangma be continued as Nokma of Rongrengri Aking, representing Rangmuthu clan, as her name has been recorded and entered in GT accordingly. Here, my lord, what happened? This hour is done in 1918, my lord, and their GT was prepared in 1927, my lord, and it has never brought
1927.
1927.
1927.
Okay.
Never brought, and they are never become the Nokma of the Rongrengiri Aking, my lord. Only suddenly in 1996, my lord, Nepilson and his wife, Regina Rising, they come into picture. Then the controversy has been started. Here, my lord, after passing this order, we make an appeal, my lord. Annex of 13.
Appeal for CM.
Yes, CM, Chief Executive Member, my lord. Chief Executive Member, what happened? Without serving any notice, any hearing, because District Council Court is going to close on 19 in 20. So before that, they are passing this order without hearing any one, my lord. They have not heard much. Just simply pass this impugned order.
Yes.
Operative part of this impugned order, page number 96, last para, my lord.
Yes.
Without hearing the parties. That the present respondent Renjing Arsangma is registered Nokma of Rongrengiri Aking representing Rongmutu Kalen by right of inheritance under Garo customary laws of inheritance and directed to continue as Nokma of the said Aking as it is so. The Executive IC Revenue has allowed the appellant lawyer for cross-examination of the respondent witness as many as 4 member witnesses, the veracity of which statement was not reversed by cross-examination, and that all the witnesses stated that there is a joint Nokma, here is joint Nokma, my lord, in Rongrengiri Aking, one from Rakshan and other from Rongmutu clan, respectively. And as such, there is no dispute about the Nokmaship of both the clan, which clearly concluded the contention of the parties accordingly. And hence the Rongrengiri Aking should be continued with joint Nokma, one from Rakshan and one from Rongmutu clan, representing the respective clan by the parties as it was before in the interest of the justice. And the appeal is dismissed in lamely forthwith for want of legal consideration. The order dated 17-1 in GD number Atho is hereby upheld and appeal is dismissed.
You're reading
This
what,
one.
page 91?
Yes, my lord.
91B.
Yes, my lord. So this order has been passed without hearing us.
96. First you see 91, now you see 96.
Friend is confused.
17 to
Yes, yes.
19. This one.
So that is the case. Now I am going to this ruling Morbo, Doreshangma and others. Doreshangma, that is para 22, my lord. I will read out 22 and 23 of the order passed by the Guwahati High Court.
You have given the list of.
Yes, I have given.
Yes.
I will go to para 22, my lord.
Yes.
The contention of the learned Advocate General Meghalaya is that the matter relating to the Nokmaship of the Aking in question having been decided in favor of the petitioner as early as 4th January 1937, my lord. By then, the Deputy Commissioner in case number 12 of 1936-37, any fresh decision in the matter is barred by the principle of res judicata. That is applicable in my case, my lord. It has been urged that even if the spirit of civil procedure code were not to apply to the proceeding under the Act, the principle of res judicata would have application. To the substantiate this contention, we have been referred to Hampstead Village versus Ekum Village, 1983, Volume 1, GLR, NOC 32, in which it was held that the spirit of Section 11 of the Civil Procedure Code was applicable in Nagaland. The same view was taken in Bhimdev versus Jinku, 1983, Volume 1, GLR, NOC 34. This view, however, could be taken because the spirit of the court was applicable in as much as the matter was adjudicated upon by the Deputy Commissioner. In the adjudicated upon the Deputy Commissioner, in the present case, however, even the spirit of the court is not applicable as noted above. Sri Lahiri has urged that would not make any difference in view of what was settled in Shatadhan versus Divarazin AIR 1960 Supreme Court 491, wherein it was observed that even if Section 11 of the Civil Procedure Code does not apply, the principle of res judicata has been applied by the court for the purpose of achieving finality in litigation. This view was reiterated in Gulab Chand Sotela versus State of Gujarat AIR 1965 Supreme Court, page number 1153, and Darja versus State of UP AIR 1961 SC, page number 1457, where it was held that the rule of res judicata is an essential part of the rule of law, which is the basis of the administration of justice on which the Constitution lays so much emphasis. It was pointed out that it is in the interest of the public at large that finality should attach to the binding decision pronounced by the court, and it is also in the public interest that the individual should not be vexed twice over the same litigation. In Lalsan versus Radha Krishna AIR 1977 Supreme Court, page number 189, it was observed in the para 9 that the Section 11 of the Code is not executive, and the next page, principle of which motivated that the section has been extended to the cases which do not fall strictly within the letter of the law. It was pointed out that the principle of res judicata is conceived in the larger public interest, which required that all the litigation must sooner than later come to an end. The principle was said to be founded on equity, justice, and good conscience, which required that a party which has once succeeded on an issue should not be permitted to the harassed by the multiplicity of the proceeding involving determination of the same issue, my lord. Now, important, my lord, para 23. This is the last para of the order. Because of what has been stated above, we are of the firm view that the principle of res judicata, which is founded on equity, justice, and good conscience, has to apply to proceeding before the revenue member also. The Deputy Commissioner, Mr. W. Shaw, having held as early as Courts January 1937, that is more than 5 decades before, that the petitioner Dorasangma was the Nokma being Khangse's own daughter. It is also too late in the day to disturb that finding. May we state that this dispute in the present case is between the petitioner who are claiming through Khangse and the opposite parties claiming through Dingma, who was the first wife of Goban Marak, whereas Khangse is the second wife of Goban. It may be that the affiliate order of the chief executive members is founded of good reason, but then that is not enough by itself to undo the order passed by the Deputy Commissioner, Mr. Shaw, on the self-same matter on 4/1/1937. The principle of res judicata would not allow us to reopen the controversy relating to Nokmaship after the death of Goban Marak. In view of the matter, we would allow this petition and make the rule absolute. Insofar as the other cases are concerned, they should not be set down for hearing on fact, my lord. Here it is clear, my lord, that our finding is 1918, my lord. And all the more than 75 years they are not claiming, only in 97. So from 97,
you are saying that the principle of res judicata would apply.
Applied, and they are claiming after the lapse of more than 75 years, my lord. Because controversy started only in 1996, my lord. Before that, there is no litigation. Raftam Kalinus continues the Nokma of this thing, my lord. And our purses were never challenged by the respondent. Now I am coming to the, because last time my learned friend is telling this and that. So High Court rules, my lord. Para 7. High Court of Meghalaya, jurisdiction over District Council Court's Order 2014, my lord. So I will go to
Yes, ma'am.
High Court rule.
क्या बोला सर हम?
Yes.
I come to Order 6, my lord, page number 196, it may be.
Yes.
I read out 6, my lord. The High Court may, on application or otherwise, call for proceeding of any civil or criminal case decided or pending in any court in the autonomous district constituted under the provision of subpara 1 and 2 of paragraph 4 of the 6th schedule to the Constitution. Hereinafter call the Court of District Council and pass order as it may deem fit. High Court has got the jurisdiction of district. Now
why you're referring to this?
No,
Where is the
there is the reason I'm coming to that.
No
Because
dispute
my
about
learned friend has already making objection that I have not prayed in my prayer petition after setting aside the impugned order, it should be referred back. But I am praying that it may be. Myself also I prayed. One prayer is there to give the judge of District Council Court, my lord. Because High Court has got the jurisdiction, it can be sent, or it can be sent to the same court, my lord. There is no problem. For that reason, because they are telling that it cannot be. So High Court has got the jurisdiction.
Okay.
No. I'm going to finish. Please patient, little bit.
I'll take 2 minutes to dismiss you.
Yes.
So my prayer is that, my lord, the impugned order passed by the EM and CM. Impugn order 17/12/2019 passed by the executive members. And the impugn order passed by the chief executive members on 16/12.
16/12.
16/10/2020, my lord, which has been passed without hearing me, my lord, in my absence. So I pray that these two orders may be set aside. And maybe remand back to the trial court or any other court as your lordship deem fit and proper. Now your terms, please start.
First and foremost, my lord, what he has submitted, to be very honest, my lord, I cannot understand. I will argue on the basis of his pleading that he has pleaded in the writ petition. What he has submitted, my lord, he has taken, my lord, asked to police bazaar, bada bazaar, everywhere, and then he brought us back to the High Court, my lord, without any substance on it, my lord. First thing, my lord, may kindly see what is the prayer of my learned senior. That is on page 17. Before going to page 17, I will take my lord to page 16.
Page
16, my lord. Para 16. Probably my learned senior is not aware of Dore Sangma itself, which he was reading, my lord. My lord, I will just read this paragraph. It's a very small paragraph. That the petitioner back to state that the Nokma dispute in respect of so-and-so Aking land has been continued since the year 1996-97 between the parties.
yes.
Thereby, prayed before the Honorable High Court that in case the case refer back for a fresh trial, it may be referred to the Judge Garo's Autonomous District Council Court on the ground that both the executive member and revenue GHDC and the chief executive member GHDC Tura are in fact politician and holding the quasi-judicial post, and as such there is every likelihood of biasness and unfairness, my lord. His presumption, my lord. Probably he, my lord, I don't want to say anything. Now, my lord, may kindly see Dore Sangma, my lord. Now, if this prayer is required to be allowed, my lord, even if my lord find that there was a wrong or there is a biasness in the judgment, my lord cannot, my lord. The division bench of Guwahati High Court, then Guwahati High Court, has decided this matter, my lord. Moreover, my lord, if my lord kindly take green book, my lord. There was an amendment, my lord. If my lord may kindly come to page 300, my lord.
Yes, sir. This is the Garo Hills.
Page 300, if my lord may kindly come to page 300.
Yes, just a minute.
Yeah, the Garo Hills Autonomous District Social Custom and Usage Validity Amendment Act 1972. Page 300, my lord. My lord may kindly see the act may be called as this. I'm just reading a short title, extent and commencement, my lord.
Yes.
Clause 1, my lord. The act may be called the Garo Hills Autonomous District Social Custom and Usage Validity Amendment Act 1972. It shall have the like extent as the principal act. It shall come into force as at once. Section 2, my lord, is very important. Insert a new section, namely section 11, to the principal act.
Yes.
It says, my lord, bar to the jurisdiction of civil court.
Yes, section 2.
Yes, my lord. No civil court shall entertain any suit or proceeding in respect of any matter falling within the purview of the act. Now, my lord, what is the parent act? The parent act is in page
160. 190.
coming, sir. I'm coming. Be patient, sir. Yes, my lord. My lord, may kindly see page 191. The relevant page is 192.
Yes.
If my lord may kindly come to section 8, my lord, of the act. 8.1, if I am permitted to read, my lord.
Yes.
Whenever a vacancy occurs in the office of the Nokma or any Aking or there arise any dispute in a matter of succession of Nokmaship of any Aking or any dispute with regard to any other matter related to or connected with any Aking and the boundaries thereof, the matter shall be referred in the first instance to the revenue member for disposal in accordance with the customary practice and the usage of the Garos. my lord. Then subclause 2, my lord. Any person aggrieved at the order of the revenue member under subsection 1 above may prefer an appeal to the CEM within 60 days from the date of order, my lord. That is the law, my lord, which decides the Aking matter or any matter within the Aking if there is any dispute, my lord. Under this, my lord, my learned senior has filed a case before the EM and then the other party has gone to the CM, my lord. And this amendment, there was an amendment and clause 11 was, section 11 was inserted, which was upheld by this division bench, my lord. That is in Dore Sangma. If my lord may kindly see Dore Sangma. Para 20, my lord. Page 135, my lord.
Yes.
My lord, I will just read, my lord. This is a very small paragraph, para 20. For all these reasons, we will hold that the revenue member alone has jurisdiction to decide the type of dispute at hand.
Yes.
But then while doing so, the revenue member has to follow this, my lord. And then, my lord, this is the appeal will lie before the CEM, my lord. So the clause 11, which bar the civil court, my lord, to decide any matter of custom or a usage of the Aking cannot be decided by the civil court, my lord. That has been upheld, my lord.
Yes, because see, in other words,
Yes, my lord.
the EM and the CM for that matter,
Yes.
by virtue of this section, para 20,
Yes, my lord.
have been bestowed with
Certain?
civil court powers,
Yes. Yes.
framing of charge.
Yes.
So on and so
A
forth.
basic requirement which is to be followed, my lord, they have laid down. And
CPC is.
the spirit of CPC, exactly, they have not said CPC, but spirit of CPC, my lord. Now, my lord, if I go into the merit of my learned senior's friend, my learned senior has only pointed out one thing, my lord, which he has harped again and again before this honorable court, that the land which was purchased jointly of 400 rupees, my lord, the private respondent, my lord, they have not come forward to register their name, and my lord, the name was inserted only on 1997, my lord.
Let us not go into that. You
No,
see,
I'm just pointing out, my
if
lord.
I can understand.
Yes.
the
No, I'm
sum-
just pointing out.
See, if I can understand the sum and substance of the petitioner's case,
Yes, my lord.
is that because he was not heard,
Hmm.
therefore,
No, I will answer to
therefore
this.
the impugn order of the CEM was passed.
Yes, my lord.
that-
That is the
that-
only case.
That is the only case.
Yes, but before he goes to that point, my lord, he has made certain other allegations. For that reason, he has been aggrieved, my lord, of the CEM order. Now, my lord, if we go into the facts of the case, just for 2 minutes, my lord may kindly see that how he is aggrieved. If it was a joint Nokma, Nokma A and Nokma B for part A and part B, my lord. Now, part B, if he is the Nokma of part A, and part B Nokma was Mr. X, my lord. Now, Mr. X, he was registered in 1927, my lord. 1927. And he has been registered for part A in 1918, my lord. 1918 by the then Deputy Commissioner W. Shaw, my lord. Now his part, he is enjoying the part, my lord. Now, but he cannot be aggrieved with appointment of the part B or non-appointment of part B. Nokma, my lord. My lord, my learned senior, very senior friend of mine, has suppressed the fact, my lord, that in 1927, the Nokma, a private respondent, predecessor, was already appointed as a Nokma.
Of Part B.
Part B. That he has suppressed very cleverly, my lord. Now, my lord, the affidavit, my learned friend will argue that part. He has filed an affidavit. I have gone through the affidavit he has supplied, my lord. It is already mentioned everything, my lord. Even then, my learned senior has not put the correct facts before this honorable court, my lord. And, my lord, now, if we see whether the appellate forum has heard him or not, for that record will be required, my lord. If, my lord, prima facie we go with the order, my lord may kindly come to the order passed by the CEM, because he is not saying that he is aggrieved with the order of the EM. He is saying, I am aggrieved with the order of the CEM because I have not been heard. Before this, going to this order, my lord, I would like to take my lord to the High Court's order. That is on page 89, my lord. My learned senior has also read, my lord. I will also like to read this paragraph, para 5, my lord. What was the grievances of my learned senior at that point of time, my lord, before the High Court?
Yes.
Para 5, my lord. After hearing the submission advanced by the learned counsel for the parties and considering the fact and circumstances of the case, I am of the view that the matter cannot move and travel from court to another court. Otherwise, there will be no end of the litigation. However, in this case, considering the principle of equity, I am giving one more chance to the learned counsel for the respondent number 1 to cross-examine the petitioner witness. Now, my lord, may kindly come to page 85, my lord. 85, my lord. Now, who was the respondent, my lord? Here is the private person, my lord. Same parties.
He's respondent.
Yes, my lord.
He's respondent number 4 here.
Yes, my lord. Now, I am giving one more chance to the learned counsel for the respondent number 1 to cross-examine the petitioner witness. Both the CM and EM order are hereby directed to see that the matter should be disposed of within a month from the date of receipt of the copy of this judgment and order. Similarly, the CEM is also directed that if any appeal is filed before him, that also be decided within a month from the date of filing of the appeal. Accordingly, I hereby set aside the impugn order dated 19/12/2013. 19/12/2013 order was, my lord, was in favor of the private person, my lord. And that CEM order, the EM order, which was in favor of the petitioner, my lord, merged with this appeal, my lord. And this appeal order was set aside. Now, my learned senior, for best reason known to him, my lord, why he was harping on those order, because that was already set aside, my lord. And my lord, sitting in Article 226, my lord cannot go into the review, my lord. This petition is not a review, my lord. Now, my lord, may kindly see the EM order, the next page, my lord. Page 90, my lord.
Yes.
This joint Nokmaship case referred by the Honorable High Court of Meghalaya on so-and-so date in writ petition number so-and-so directing this court to cross-examine the petitioner witness. Upon directing this court complied with the order of the Honorable Court and heard both the side in details accordingly. On perusal of the record available in the office and also deposition of the witnesses, this court observed as indicated thereafter. My lord, this order was passed after complying the Dorai Sangma's judgment, my lord. There is no doubt about it, my lord. And the private person was also given an opportunity to cross-examine the witness of the petitioner. Now, if my lord may kindly come to 5th para, my lord.
Yes.
The GT in respect of Rongmutu clan was prepared on 15/3/2027 and duly approved by the by the then Deputy Commissioner, 1927 I say, was duly approved by the Deputy Commissioner, declaring so and so Mesa and so Michik is a lady, male Nokma and female Nokma, were the first registered Nokma of so and so Aking from Rongmotu clan. The present petitioner, so and so, along with her husband, was recognized as Nokma of so and so clan on 22/8/1997. Now, the question here, why, my lord, got it, my lord?
You reading para?
Para 5, my lord. Page 90 itself, my lord.
Okay.
Yeah.
This is the third para.
Fifth para, the GT.
Yes.
The GT is in respect of Rongmotu clan was prepared on 15/3/1927, my lord. My lord has gone through this, my lord, and still continue the same of Nokmaship representing the Rongmotu clan. Now, my lord, here the question comes that my lord senior has harped, my lord, very heavily on this date. He said it is a very important date. It is 22/8/1997. What has happened in 22/8/1997? He has not said anything. On this date, my lord, the private respondent approached the CEM and EM, my lord, revenue, in charge land and revenue, for registering their name. Obviously, my lord, after my father and mother expired, I have to go and register my name. When my father and mother are still there, my lord, from the time of 1927, my lord, they are still there. I'm not required to go and register. After the death of my father and mother, I will go to the EM for registration, and they have filed an objection. Now, for Part B, as I have explained, my lord, for Part B, how he is concerned, my lord? When it is Aking, he is not disputing that it is not a joint Aking. If it is joint Aking, if there is a vacancy and I don't approach the EM for a particular period of time, maybe because of the ignorance of law or whatever reason, my lord, subsequently I go, how he can be aggrieved? Now, my lord, coming to this para, my lord, if my lord may kindly come to para 7, my lord. The last para of that page 90, my lord.
90.
Yeah, page 90, the last para.
Yes.
Judge GT in respect of Rangsam and Rongmotu clan is very clear on record as on today, which shows different and separate Ma MB. Ma MB is genealogical tree, my lord. That means both of them, they have their own genealogical tree. There is no question that in his genealogical tree, my lord, private respondent name should be included. He is harping on that, my lord. Now, my lord, we kindly see for both Raksam and Rongmotu clan respectively, and cannot be denied at this junction, which clearly include the contention of the parties. Accordingly, hence, so and so Aking will be continued by joint Nokmaship, one from Rangsam and one from Rongmotu respectively clan as it was before. So, my lord, from the British era, my lord, there was two Nokma, joint Nokmaship. Now, if a private respondent, my lord, for whatever reason, my lord, they are supposed to answer and satisfy this honorable court, they have not approached the EM to register. Subsequently, they approach, my lord, if there is a gap, how come, my lord, he can take advantage out of it? Second thing, my lord, if my lord may kindly come to the order which was passed by the CEM, that is on page 95, my lord, on appeal, my lord. An appeal was filed by London senior, my lord.
Yes, yes.
He is saying, my lord, that he was not hurt, my lord. But prima facie, from this record, my lord cannot go beyond saying that, my lord, he was not hurt. Hurt the parties. It's not said, my lord, that hurt the parties. That means both the parties, my lord. Now, for this point, my lord, record has to be examined. That whether they was present on that day or not, my lord.
Do you still have the practice of filing hajiras?
That I have to examine, my lord, from there, the record, my lord, whether
before CM or
probably they have, my lord. Probably they have. I will call the record, my lord, and on that day I will produce the record, and then my learned friend can continue his submission, my lord, if he has any.
I have submissions to make. My learned friend was submitting that.
But your case would be, as if I understand correctly from what Mr. D has submitted,
Yes, I have
your
some
case would be
factual-
distinct.
Because they say they're continuing from 1918, but that's not the case. Till 97, I was there. Then this issue cropped up. Then it went to EM, then CEM, then High Court, then back to EM, then to CEM, then High Court, then back again.
Because the
But
real fact,
finally, it was decided in my favor by the EM and the CM. And these are concurrent findings which are based on evidence, depositions. There was no cross-examination on their part. Now, Your Lordship, under 226, my learned friend has filed on violation of natural justice. Now, on a concurrent order, Your Lordship, in my humble submission, he has to challenge the decision-making process, which he has not done so. To show that there's some irrationality, there's some procedural impropriety, Your Lordship, and there's some illegality in the order.
Basically, that is the essence of judicial review.
yes, my lord, and moreover, my lord, I don't know how far my lord will buy my argument. This petition itself is not maintainable, my lord. According to my understanding, my lord. My lord may kindly see the first round of litigation that my learned senior has come and challenged this order. That is on page after verification, my lord, page 21. Now, my lord, he has filed a CRP, which is registered as CRP number 6 of 2021, and by wide order dated 17/3/2021, he has withdrawn, my lord. So the part of withdrawal, just I will read out, my lord, 2 lines. On the prayer of the learned counsel for the petitioner, this application is allowed to be withdrawn with liberty to file afresh, if so advised. Accordingly, matters stand disposed of on a withdrawal with liberty to file afresh, if so advised. File afresh what, my lord? It's not that he has CRP, my lord. He has come under 226. To file a writ under 226, he has not taken any liberty from that code, my lord. Can this petition be entertained, my lord?
You were supposed to file a...
He has filed a CRP.
CRP.
He has withdrawn it. He has not mentioned anything, my lord, before that code that wrongly I filed CRP. I may be allowed to withdraw to file writ petition under 226. So that should have been clarified, my lord. By allowing him to withdraw, my lord, CRP, and he has taken a liberty to file a fresh CRP only. So whether this 226 will be maintainable, and there is no delay, which was explained also, my lord.
We're not going to delay because he's taken a liberty to file a fresh.
But that point has to be made clear, my lord, before this honorable court.
That has not been clear out by him.
So I will pray, my lord, at this stage. At this stage, I will
I
pray.
think, the only thing is, see, first we have to address the issue of non-appearance, or rather, not being given the chance to be heard.
Yes.
That's number one.
Yes.
If that is satisfied, then we'll go into the other aspect.
Yes.
Whether his claim is justified or not.
Yes, my lord.
Whether the
Now his claim is justified or not, my lord. My lord cannot go. According to my understanding, my humble understanding.
This court can't go into that.
Yes, my lord. Now, only thing is this: whether he has heard before the CEM.
That is the only issue.
Yes. 1 minute. 1 minute. Even if my lord find that he was not heard, my lord, what will happen? My lord will set aside the CEM order, will remand back to the CEM, my lord. But EM order will still remain, which is in favor of the private respondent. Yes. So I will pray, my lord. 2 weeks time may be given to me. I will call for the record, my lord. My lord may examine this, my lord. So this was the only issue, my lord, of 5 lines, where my learned senior has taken 2 hours, my lord.
Anyway, I think that will be...
They are very expert, so within 2 lines they are finishing, but taking more than half an hour. Anyway, my lord. Anyway, my lord.
Without going into the records also on that liberty that he has taken, Your Lordship.
That he has to satisfy this honorable court.
No, here, my lord, what happened, my lord? It is come to the Chief Justice. He is telling you I have filed WPC. Then he is telling verbally that CRPC is applied in case of the District Council Court.
He could not satisfy the Chief Justice, my lord. This is not my mistake.
Then I come to this thing. Then this with justice, thank you. And I have to withdraw, then I will file a writ petition. Writ petition, though it is different things, my lord.
No, no,
See,
no.
it
It
is
cannot be different
different.
things.
But it was, see,
No, no, so
if
that
if-
is the reason.
But if there is no specific order,
No, no, it is understood, my lord, because I have
No, no, no.
because wrongly I filed this CRPC. So I pray before the court, I wrongly file it. So I have a liberty to file afresh. File afresh means
those are technical issues. We'll look at.
But
that
my
is
lord,
the minor
technical
issue.
no, that is not a minor issue. That is one of the very strong issue that I have raised, my lord. And my learned senior has to answer this, my lord.
He'll answer.
Yes, my lord.
Liberty to file fresh.
I'll address your lordship after the record comes.
Mr. A.H. Ajeka, learned counsel for the petitioner, has concluded his argument. Mr. S.D. learned SC, JHADC has also advanced his argument on behalf of the said respondent. However, the learned counsel has submitted that for clarification, the relevant records with the JHADC may be allowed to be produced on the next date fix. Accordingly, the prayer is allowed. The hearing will continue on the next date fix.
It remains as part hard, my lord, since petitioner has already.
It's already hard.
When I say it will continue means
My lord, my lord, my lord. My lord.
I've never.
It's
never
very
said,
difficult to stand, my lord, in front of the senior, my lord. He keep on murmuring something or the other. I cannot get, my lord.
Because my lord, when I am arguing, he is murmuring more. I am keep silent. He have to understand himself first and others. Anyway, my lord, we have concluded.
Hello,
This is 2 weeks. 2 weeks, Mr. D.
my lord, my lord.
Much.
Item number 12.
Yes.
Please, Your Lordship. Your Lordship, as per the last order, Your Lordship, we had to call for the records, Your Lordship. I've already submitted a copy of the records, Your Lordship.
This is that tanker case.
Well, yes. The FIR,
The only
actually
thing,
the
sir-
seizure list is, my lord, in handwriting. I have got
No,
it typed.
Mr. Bora, the only thing that you have to establish, which I don't know whether you have been able to convince the IO that you are no longer the owner of the vehicle at the relevant point of time. That is your stand, isn't it?
I didn't get you, my lord.
Your stand is that you are no longer the owner of the tanker.
I'm not the
At
owner
the-
during that
at
time.
the
Yes.
relevant point of
That is
time.
my point, yes.
Now, previously it was in your name. Previously it was in your name.
Yes.
Registered in your name.
Yes.
So if there is a transfer, then a seal deed has to be there, or you may have to fill up form 2930 for transfer of name. Have you done that?
My point is that at the time in question, the vehicle was not in my custody. It was in the custody of the person who had taken it on rent.
Oh, on rent.
Yes, my lord.
But even if it is on rent, then it will still remain in your name.
The original papers are in my name. I had given him for running only.
Your Lordship, he was named by
At
the
the rent of
co-accused.
10,000 per month. He had hired my vehicle for running at the rate of 10,000 per month. He was supposed to bring oil only.
Okay, fine.
In the tanker.
See, in that case, then there's no issue here as far as the ownership of the vehicle is concerned. Because if I understand correctly, you say last time that the vehicle is no longer in your, in your name.
Yeah, originally, or I'm the original owner, but during the period, the vehicle was on rent with the accused. Yes, that's.
It may be on rent. If you on rent, have you produced?
So my vehicle has been seized under Section 60.
Have you produced the relevant papers? Rent agreement or?
Yes, yes, my lord. The agreement is there. I had.
Okay. That has been produced before this IO.
Not yet, not my lord.
Why? What is the stage of the case then?
Because I had never faced the IO. I was at home when I got the notice from the court that I have been shown as absconder by the IO.
Okay.
I never met the IO. I was shown as absconder and I got the notice from the court. I appeared in the court and took bail. And I was waiting for the time to file my petition under 227, but it was possible only after the COVID lockdown and all. Before that, I had no opportunity to file. Meanwhile, one accused had died. In the proceeding to get his death certificate also took a long time.
Now, before the trial court,
my lord,
when the matter was, taken up for consideration of charges.
Yes, my lord.
You were present?
Before that, actually, before the court fixed a date, I had filed an application under 227, my lord.
Okay. You may have filed.
Yes.
It comes to the same thing.
Yes, my lord.
Now, before the court, have you pointed out this fact?
Yes, my lord. I have given a copy of that.
That you were not examined by the IO? That you have not been given the opportunity to present your case as far as the vehicle is concerned, that it has been rented out?
Yes, ma'am.
Have you?
Yes, I have given it in that. In my petition under 227.
Was it noted in the impugn order?
Yes, ma'am. It has been. It has come in.
And not considered.
Yes, ma'am. That is why the case has also been referred to by the learned court below, that a Supreme Court order of 96, which says that an evidence brought by the accused at that stage, at 227 stage, can also be considered by the session court. Should be considered by the session court. That is the core point, actually.
Then why? Why it was not considered?
That rental agreement with me and the accused has been produced in the trial court during the stage of 227. Now, the court has mentioned a case where also the Supreme Court has agreed that at this stage also, any evidence which the accused may bring should be considered by the session court.
Yes.
That is what is the point. If that is considered, then other than that piece, there is nothing against me in the case. So there is nothing to proceed for trial against me. That is why I had prayed that I may be discharged.
But before your discharge, you see the conduct of the investigating officer has to be looked into.
Yes, ma'am.
Where is the impugn order?
Page 24, Your Lordship.
The learned court below has tried to say that even that a piece of evidence should also be examined during trial. That is the intent of the learned court below. Here, that has been mentioned, page 26, my lord, the first paragraph. The learned court below has observed. Page 26, my lord. First paragraph. Since the accused has also produced the lease agreement of the tanker executed between him and the co-accused Kamal Chaudhary as a material to convince for his discharge, in Satish Mehra versus Delhi Administration, etc., 1996, 9 SCC 766, where the Honorable Supreme Court has held that if the accused produces any convincing material at this stage of framing of charge, which might drastically affect the very sustainability of the case, it is unfair to suggest that no such material should be considered into by the court at that stage.
Your Lordship, even the lease agreement was not registered, Your Lordship. It was not registered, Your Lordship, and he was named by the co-accused, Your Lordship.
I had regarding that also I had submitted one ruling of 2009 for SBR 56, which said that the statement of a confessional statement of a co-accused could not be used as a substantive evidence against the other co-accused.
That would be during trial.
Yes.
But you see, as far as investigation is concerned, that would be material because the IO, you see, the IO has to look for some evidence,
yes. IO
some way
has
to link,
yes.
you see, to link the case, to link the parties involved, whoever.
I should have known,
So
but
after
my
investigation-
unfortunate position was that I never met the IO. I came straight
Your
to the
Lordship,
court.
because he was absconding, Your Lordship.
No, I was not absconding from my side. It was the IO who thought I am absconding because he had not sent any someone to me before at my address. I got the notice from the court, not from the police or the IO. I'm not in Meghalaya. My residence is outside Meghalaya. I didn't get any notice from any police officer or any police station. I got the notice from the court where I was shown as absconder. I promptly appeared in the court and took bail from the court.
So charges have been framed.
Yes, Your Lordship.
Against that other two accused. Against me, charge not yet framed.
Oh, against you.
Not yet framed.
Now, was the IO in possession of this lease or rental agreement?
Your Lordship, I have to take instructions, Your Lordship.
Because subsequently, if he has, or if previously rather, if he had received such a piece of evidence, material evidence,
I'll have it was
it has to be considered.
from the records, Your Lordship, from the order, from the impugned order, it was produced in court, but
Vehicle not released. Vehicle has been seized under Section 60 and
We are
EPS
talking about the rental agreement.
yes, Your Lord, the lease agreement.
So that was produced by you before the
Yes,
court.
my lord.
Whether it
That
was
was on
given or not
rental
to
from
the
me.
IO, I'll have to
When
take
the IO
instructions.
seized the vehicle, he seized it under Section 60. So it has been seized and it has not been given back. Under Section 60, vehicle used for
No, not the vehicle. I'm talking about your agreement, your rental agreement,
yes, my lord.
lease agreement. That
Yes, that has come
that
first
document.
to the court with my application under 227 only. It has
Your
not come
Lordship, if
before
you
that.
look at page 13, the lease agreement also, it's a very incomplete, not convincing lease agreement, Your Lordship.
With the bail application, I had filed one there also. With the application under 227 also, I had filed one. Here it become, due to the Xerox taken time and again, the signatures may have.
You have not annexed a type copy of this.
The type copy
I
is
have
in
given
page
on
12, Your Lordship.
page 12. The signatures are not seen here because of the
Yes, of course.
repeated Xerox.
So a copy of this would be with the
Trial court, my lord.
no copy. You see, when a lease agreement is of
Yes,
this kind is executed, you will have a copy,
I'll have a copy.
and the other party will have a copy.
Yes, my lord.
The other party is the co-accused here.
Co-accused, yes.
He doesn't have
He
the copy.
suppressed that agreement from the police. He ran away when the police arrived. He was found in the early morning on the roadside. He was trying to hitchhike towards Silchar. He was caught by the police, and papers seized from him did not contain this lease agreement.
See, Mr. Bora, you have to show before this court under what provision a reinvestigation can be directed. To direct the IO to take cognizance of this lease agreement,
Yes, my lord.
to go into the to go into the matter,
Yes,
examine relevant witnesses,
yes, my lord.
and then come with a finding that
That
whether,
would be fine, my lord.
you see,
Yes.
as Mr. Slingwa has said, whether this agreement is really valid or not, whether it was done properly or not.
Yes.
That's number one.
Yes, my lord.
And if it is found to be genuine, whether it will exonerate you or not.
Yes, my lord.
To that extent, I think only the IO could do it. The court will
Yes,
not be
of
able
course.
to do it because
He can still file a
even
second
even if it
CS.
comes
Yes.
in course of a trial.
Yes, my lord.
I don't think that.
Yes, my lord. That would serve the purpose.
But what is the relevant provision? 156(3) will not. I don't know whether this provision will suffice.
FIR, there is no formal FIR actually. The seizure list.
I'm not talking about fire. I'm talking only about directing the IO to reconsider his investigation.
In light of the evidence,
In light of-
this evidence.
in
Yes,
light
my
of
lord.
your-
That would be fine, my lord.
Show me the provision.
The profession.
173 itself only for the 173
173 is
clause
filing
8,
of
I suppose. I didn't
173
really
is filing of the final report.
Yes, my lord. Clause 8, he can
But
go
you
for
see,
further
now 173 is
investigation.
filing of this final report. The IO, in his judgment and wisdom, and on the basis of investigation, has filed the final report.
Yes, my lord.
Now it is not known to him as to what additional
Under
evidence are
173
there.
clause 8, I
Now
think he
if
can file
now if additional evidence
Yes, ma'am.
has surfaced
Yes, ma'am.
in this manner, what is the provision either for the court or for the IO to
IO can
suo
file
motu,
a further report under 173 clause 8, I think.
who is to direct that?
Can I see clause 8? I think clause 8.
Because reinvestigation,
Not reinvestigation, my lord.
that would
Additional
be,
charge sheet.
because that would be only under the provision of
Yes,
156 or 153, 156(3. But I don't know what is the provision.
173 clause 8. If I nothing in this section shall be deemed to preclude further investigation in respect of an offence after a report under subsection 2, etc. Further, the power for further investigation, I think it's clause 8, my lord. To the magistrate, whereupon such investigation, the officer in charge of the police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed, and the provisions of subsection 2 to 6 shall, as far as may be, apply in relation to such report or reports as they apply in relation to a report forwarded under subsection 2.
I think this would be the relevant provision. Heard Mr. P.K. Bora, learned counsel for the petitioner, who has submitted that this application is filed under section 397 CRPC with a prayer to set aside and quashed. The impugn order dated 19/4/2023 in passed in criminal NDPS case number 15 of 2020 under section 227 CRPC, which case is pending before the court of the London Special Judge NDPS at which district? West Gentia. West Gentia Hills.
East Gentia Hills, my lord.
Hills, Your Lordship.
East Gentia Hills district. The case, Mr. Bora has submitted that the case of the petitioner is that he was the owner, or he is the owner of several oil tankers which have been let out to various parties and for which he would receive the rental amount as agreed to between the parties. One such vehicle is the oil tanker registered as NL02 6412, the same being rented out to Shri Kamal Chaudhary of Nayapura, Kamrup district, Assam. A lease agreement to this effect was also executed between the parties, being, where's the date of this agreement? You have a copy of the agreement with you? The agreement with you, do you have a copy of it?
The same photostat copy I have.
Here is not legible.
Another photostat copy also with the party. I'll collect that also.
You see, I cannot depend on your.
This has been Xerox several times. That's why I'll get the first Xerox copy also.
I cannot depend on your.
Give it to the IO.
Type copy because we don't know. Trying to. Just try to find out what is the details here. April 20.
Type copy is the previous page, not page 12.
No, forget about the type copy. We'll look at
First day of April, Your Lordship, 2004.
That's paragraph 2, isn't it?
Yes, first day, 1st April 2004.
1st April 2005 or 2004.
Kumnu tuko? This is it. They being which becomes operational with effect from first day of April 2004. The rental amount. What is the rental amount?
Rental 10,000 per month, my lord.
Rental amount being 10,000 per month.
Advance of 1 lakh paid.
With advance of 1 lakh being advance of 1 lakh having been received by the petitioner. Thanks. It is also the case of the petitioner that the said vehicle in question was apprehended by the police suspected of ferrying Is it contraband?
Contraband.
Contraband substance. Ganja.
Ganja, yes.
I under bracket ganja. Upon which the police had apprehended the said vehicle with the driver of such vehicle being arrested. In course of investigation, the co-accused had informed the IO that the vehicle belongs to the petitioner. Petitioner. Accordingly, the petitioner was made a co-accused in the case, being registered as where is the initial case was registered as
Your Lordship, GR case number 329 of 2005.
GR case, yes. That is in the at July, when the case was in July.
GR case number 329 of 2005. So July police station.
Yes, Your Lordship. Your Lordship, if I may, Your Lordship. Your Lordship, this section 173.8, Your Lordship, it specifically says that if the IO, the investigating officer, obtains further evidence, but in this case,
exactly. Now he has not. You see, in this case, he has not obtained,
Yes,
but
Your
it
Lordship.
has transpired. You see, now it has come. It has come in due course.
In due course.
Now the court has taken, the trial court rather has taken cognizance of such evidence. Do not accept it.
Yes.
Now, when the matter came before this court, it is the opinion of this court that such matter has to be looked into by the IO. So that would be, see, now it is incumbent upon this court to inform the IO, rather to direct the IO, that you take this into consideration.
Further invest, yes.
Take this piece of evidence into consideration in, in accordance with the provision of 173.
To examine, Your Lordship.
So that would be knowledge for him. As it depends on him. If again, as I have said, the court will not interfere with the manner of investigation.
Yes, Your Lordship.
He may come up with he will file a supplementary charge sheet, and if the accused or the petitioner is found to be involved, so be it. Wangunum tu? Again, the learned counsel for the petitioner has submitted that the petitioner is not aware of such investigation being carried out, or that his vehicle was also involved in the case, since he is residing, where was he residing?
Hojai in, now it's Hojai district.
Assam.
Yes, my lord.
He is residing in Hojai, at Hojai district, or in Hojai district of Assam. In the meantime, it is learned that the IO had declared him an absconder, though it is reiterated that no notice or summons have ever been received by the petitioner. You were arrested in due course.
Pardon?
You were arrested, or how did
I
you?
was not arrested.
Then how did you come before the court?
I got the notice from the court and I appeared in the court, my lord.
The petitioner would submit that the letter counsel of the petitioner would submit that the petitioner, however, in due course had received summons from the trial court and has appeared before the court
and obtained court bail.
And had obtained court bail. In course of proceedings before the trial court, the petitioner has filed an application under section 227 CRPC with a prayer for discharge on the ground that the said vehicle in question was never in his possession, but the same was leased out to the co-accused. However, this piece of fresh evidence was not taken into account or cognizance by the trial court for the reasons stated in the impugned order, and eventually the trial court had rejected the prayer of the petitioner and had directed that charges be framed against him. It is also mentioned that till date no charges have been framed against the petitioner, though charges have been framed against the two. Was there two or one? Two co-accused or one?
Total 3 accused.
Two. Against the other 2 co-accused. Mr. Bora has stressed on the fact that the lease agreement is very material and essential as far as his innocence is concerned, but for the IO who have not been made aware of such piece of evidence in course of his investigation. Accordingly, even at this stage, in the light of the provision of section 173, in light of the provision of subsection 8 of section 173, this court may be pleased to direct the IO to reinvestigate the case as far as the petitioner is concerned and to file his findings before the trial court. The Learned Counsel has also referred to the impugned order and the portion. Where is the impugned order? Where is the order of the and the portion wherein the Learned Trial Court has referred to the case of Satish Mehra versus Delhi Administration and another reported in 1996, 9 SEC 766. Wherein the Honorable Supreme Court has held that if the accused produces any convincing materials at the stage of framing of charge, which might drastically affect the sustainability of the case, the court should consider such material at that stage, that is, at the stage of framing of charge, at the stage of consideration of charge. In view of the above, the Learned Counsel has submitted that this petition may be allowed and the impugned order may be set aside and quashed to the extent indicated, to the extent prayed for. And what do you say?
Your Lordship, first of all, Your Lordship, the lease agreement is not convincing enough. It's not even a registered lease
IO will
agreement.
find out about it.
So if the material is being provided to the IO, then it can be examined.
Yes, I
Definitely.
mean, that we leave it, like I said, we leave it to the IO. For all we know, he may not find, like you said, he may find that the lease agreement is also
Yes, Your
forged
Lordship.
document,
Yes,
this, or whatever the case may be. That is not for us to
Up to the
decide.
IO, that one.
Miss Alawan Lanet G, appearing for the state respondent, though has not made any strong objection to the submission made, but has, however, pointed out that the copy of the lease agreement annexed by the petitioner in this petition is not a legible one, and prima facie it appears to be a forgery. However, the learned GA had left it to the discretion of the court to direct the IO to take necessary steps in this regard. This court, on consideration of the submission made by the parties, without going to the details of the merits of the case, on the submission of the learned counsel for the petitioner, would agree that the veracity of the lease agreement and its importance and impact as far as the case of the petitioner is concerned has to be examined and taken into account by the IO, who, though not of his fault, has failed to take such piece of evidence into consideration before filing the charge sheet, before filing the final report and the charge sheet under section 173 CRPC. The authority cited, that is the case of Satish Mehra Supra, would also be relevant as far as this case is concerned, and it is the opinion of this court that the material which ought to be taken into account by the IO has not been done so. Perhaps if the same is investigated into, it may affect the case of the petitioner, either to find him to be part of the alleged offence or not. A perusal of the provision of section 173 it would also show that if the officer in charge of the police station obtains further information, oral or documentary, he shall forward the same to the magistrate, meaning that a further investigation has to be carried out and the report of such investigation is to be produced before the magistrate concerned. Though in this case, unbeknown to the IO, the evidence, so-called evidence, has been produced by the petitioner. This court would consider it fit and proper that this piece of information, that is the presence of the said lease agreement, has to be made known to the IO for fresh investigation to be carried out. Accordingly, the IO is directed to take into consideration the presence of such lease agreement and to embark upon further investigation in the matter as far as the case of the petitioner is concerned, and an additional supplementary charge sheet will be filed before the trial court. Accordingly, to the extent indicated above, the impugn order is hereby set aside and quashed. The trial court is also directed to take necessary steps as far as the direction to the IO cited above, direction to the IO given herein is concerned. Matter disposed of.
Much obliged.
Right, Lordship.
Item number 13.
Please, Your Lordship. My Lord, this is the bail application matter where my Lord, I was pleased to grant me interim bail for the checkup of my father. My father was in ICU.
Okay.
That is brain hemorrhage, my Lord recollect.
So what happened to him? He has recovered.
Yes. As per the last order dated 27/5/2024, my Lord. If my Lord read the last para, however, as an interim relief, the court will grant interim bail to the accused person in question on condition that he should not abscond or tamper with the evidence and witness, and that he shall appear before the investigation officer as and when required. So I have appeared, my Lord. They have called me. I have appeared also, and now, my Lord, the situation is this, my Lord. My father condition is same, my Lord. Now we have shifted from Tura Civil Hospital to Guwahati, my Lord. That are the record that I am placing it. If my Lord may kindly see page 9, my Lord, first. Wait. After my father was brought to Guwahati Hospital, my Lord, Metro Hospital, my Lord, Guwahati Metro Hospital. My Lord, these are the tests which was given to my father. Now, my Lord, may kindly see page 18, my Lord. Page 18. The patient may need ICU care later on. In the case of ICU care, the patient party has been consulted in a language well known to them. My Lord, my name is Selnang, my Lord, CH Marak, the accused person, my Lord. So, my Lord, today we have shifted him to ICU, my Lord. Yesterday we have taken him to Guwahati. They have put him in observation. Now he has been put in ICU, my Lord, my father. So, this is the situation, my Lord. And my Lord, if my Lord may kindly come to page 23. My Lord, page 23 of the medical report. If my Lord may kindly see the signature of the patient, signature of the attendant, Selnang CH Marak. So I am the one who is taking care of my father. So this is merely an application, my Lord, for mercy. My Lord may consider it as a mercy petition. Since my father is in a very serious condition, my Lord, it is why I am before this honorable court to grant bail, my Lord, to me, so that I can take care, my Lord. This is a condition, my Lord, where my father is in coma from the day he was taken to Tura Civil Hospital. After my Lord's order, I've gone and appeared before the IU, and whenever it is required, my Lord, I will go, my Lord. But at present, my Lord, my condition is this, my Lord, that I have to be with my father, my Lord. as his son, my lord, I have no other option, my lord, to send some other brothers and all, my lord. They are not there, my lord. So, my lord, may kindly consider, my lord, this application. Moreover, my lord, I was more than 60 days in jail, my lord. So, after my lord's order only, my lord, I have been released. And my lord, till date, my lord, charge sheet has also not been filed. That is my prayer, my lord, subject to my learned senior, what he placed, my lord, before the
90 days up.
No, my lord, 60 days has been passed.
90 days of course, not.
No.
Charge sheet can be filed within 90 days.
Yes, my lord.
Yes, Mr. Khan, what do you say?
So for this ground that he has stated, Lordship, I leave it to the discussion of the court. That part, I don't think so. On moral grounds, I should object. And besides that, Lordship, the latest status report that I have got, it appears that Sonar Ali, who was the main accused, he has just mentioned about the present petitioner. I can give the extract of the case diary, but not specifically as to what was his role. The specific role, Lordship will see it.
I mean, you see, he was, at the scene.
At the scene, but what exactly
no,
he did?
Exactly, my lord. If I can explain, my lord. We was going, my lord, attending a marriage, my lord. I was returning back to Tura.
Marriage or election?
No, election campaign was there. Subsequently, I went to attend marriage, my lord. Then I was on my way to Tura, my lord. Then we spotted, my lord, that the vehicle has been burned down, my lord. We get down, my lord, to see. And the person, who the driver or the handyman, my lord, he saw us. He thought that it was we, my lord. It was not we, my lord. Otherwise, no other person who was occupying the vehicle, who was traveling along with me, my lord, has been charged with, my lord.
So agreeing with my friend's submission, that is exactly what's happened in the case diary also. Like Sonar Ali has mentioned that the present petitioner was involved, but without specifically saying how he was involved with it, directly involved. So that evidence is not there. Number one. Number two, TIP parade was done as per the case diary, and that stage also is over. And there was some recovery of facts that also was done.
No, the victim has identified him.
Yes, identification is there, but not with regarding to the role. Presence, yes. So that part has not come.
We are not denying, my lord, that I have not traveled.
No, any statement of the victim?
No. Just identify the not victim has just identified them, but what was the role that has not come? Neither by the main accused nor with anybody.
First thing, we have to establish the fact that
he was present. Yes.
Victim is known to the petitioner.
Yes.
Or to the accused person. Is he known to him?
Yes, my lord.
So if he is known to him, if at all he was involved in in setting fire to the vehicle or in assaulting him, then definitely he would have stated that.
That is not there. That is not. That is absolutely correct.
Is his statement there?
No. I can give the extract 7, para 7, 8, 11, 14.
Oh, just show me the 161 statement of the victim.
Lordship will see 7, 8. Paragraph 7, 8, 11 and 14.
Para 7 is very clear.
Lordship, yes.
He was the one who had
ordered the accused Shri so and so and his associate to execute, and the same was done on the night of 16/3/2004.
So that is referring to the incident that occurred.
Lordship, yes, but there Lordship has posted a question when granting anticipatory bail. What exactly was the role? Giving orders is one thing. So that part, Lordship has to execution. Yes,
that would have to come out in course of investigation.
Yes, but so far, Lordship, that has not come out except using associates. That is the number 8. Lordship, 8 will see the recovery of facts. Para 8. Same thing. And 11 is the TIP, Lordship.
Part Mr. SD, learned counsel for the petitioner, who has submitted that this court, by the order dated 27/5/2024, had granted interim bail to the accused person, Shri
Selnang CH Marak.
Selnang CH Marak, who was arrested in connection with Abati PS case number 27/3 of 2024 under section plus IQO. The reason for such allowance is that the father of the accused person in question is suffering and is in a coma, and has been referred to hospital, where he is in the intensive care unit, ICU. It is the submission of the learned counsel that the condition of the father of the accused person has not yet improved, and he is still in a coma, but has now been shifted to a hospital.
Guwahati Metro Hospital.
Shifted to Guwahati Metro Hospital, where he was also admitted in the ICU ward. In the ICU, the accused person being the only person who has attended to his father in the hospital, is required to continue such attendance till date, and as such, on this ground alone, the prayer for grant of bail is made. Mr. Kekhan Leonard PP has not made any strong objection to the prayer made, but has, however, and has also referred to the progress of the investigation to state that one of the co-accused,
Two of the co-accused, my lord.
both of them have given similar
Yes, my lord.
statement.
Yes.
Two of the co-accused had given statement before the police indicating the involvement of the accused person, but to what extent and in what manner such involvement occurs has not been cited by the said co-accused person, who are said to be eyewitnesses of the incident. Where is the reference about TIP?
Nick, TIP is at para 11.
The learned PP has also submitted that during TIP, that in course of the TIP conducted, TIP I full photo test in identification parade, the victim has identified the accused person as being present at the scene of the incident. The learned PP has, however, submitted that no concrete evidence has been found as regard the mode and manner of involvement of the said accused person. Next. This court has considered the submission made and has also produced the documents produced by the petitioner, which are the records of the patient, that is the father of the accused person, before the Guwahati Metro Hospital. There is no denying the fact that the father of the accused person is in ICU in the said hospital till date, and for which the accused person is the only person who is attending to his needs. Though it is well settled principle of jail jurisprudence that bail is the rule and jail is the exception, in a katana of judgment passed by the Honorable Supreme Court, guidelines and parameters have been laid down as to the circumstances under which bail has to be can be granted or not. One of such guidelines is the fact that the court has to look into the nature and gravity of the alleged offence, the complicity or involvement of the accused and the evidence thereto, and also the fact that the accused may abscond. Next. Though it is not though it is also well settled that bail is the discretion of the court concerned, though the same has to be looked into or passed, though the same has to be considered after looking into all the facts and circumstances of the case and taking into account the set principles as indicated here and above. The case involving the accused person is indeed serious. However, investigation is under course. An investigation is still going on, and it is the submission of the learned counsel for the petitioner that the accused person had in the meantime appeared before the IO. Has he given his statement?
Yes, yes, my statement has been recorded.
And has got his statement recorded. This court, the Honorable Supreme Court, in the case of Sanjay Chandra's Agatoka citation, para 21 and 22, has observed us under on an overall consideration of the submission of the parties and the facts, submission of the parties. This court is of the opinion that the prayer of the petitioner can be allowed at this point of time. The accused person, Sri Senlaksy Smarak, is accordingly directed to be released on bail on the following condition: that he shall not abscond, that he shall not leave the jurisdiction of India without prior permission, that he shall bind himself on a personal bond of 50,000 with one surety of like amount to the satisfaction of the IO. Any other condition you want to?
We should cooperate, tamper with the evidence in that part.
That of course.
It's already there.
We have those issues. Not necessarily to dictate it. I will just copy and paste this. They shall not. That he shall cooperate with the investigation as and when required.
Lordship, just a point of clarification with the leave of the court. Sanjay Chandra is regarding economic offence.
No, I understand. Sanjay Chandra is with regard to economic offence.
Absolutely.
But as far as principle of bail is concerned,
Absolutely correct.
Para, we
Para 21, para.
more often than not we rely on para 21.
Highly obliged.
Item number 14.
What do we do? So, Mr. Khurshid.
Well, it's item 15, if your lordship would please to take up item 15 first, because I think that's what your lordships had indicated last time. Well, it's my friend, learned friend on the other side, they had responded to our arguments. My lords, I believe that there was nothing substantive in contradicting our arguments. But, my lords, I am ready to re-emphasize what I'd argued before your lordships. But alternatively, my lords, your lordships had indicated that we would be allowed to file written submissions, both sides. Their written submissions have not come yet. We are almost ready with our written submissions, and those will be ready in 2 weeks for us to file. But if your lordships would like me to refresh your lordship's mind on what our arguments are essentially, then your lordship will give us a few moments and we can do that.
I don't think that will be necessary because, like you said, you see, basically I've heard you, I've heard the other
Please,
side. If you insist, rather if you desire to file your written argument, that would
Yes.
be helpful to the court.
I'll be very grateful. My lords, if your lordship will give us 2 weeks, we will have them done and placed before your lordship.
Fine. Have you filed yours, Mr.
I have
Dr.
not filed mine. We'll file it in the meantime. But I was praying for a little longer time, 3 weeks time.
Do the written argument needs to be exchanged?
Well, let's as a courtesy, we might exchange them. I don't think that's necessary to exchange arguments, but as a courtesy, because there's no question now of responding to written arguments.
But we'll exchange, my lord. There's no counter written argument.
And in any case, you see, the crux of the whole argument would be on law points.
Well,
that has been addressed by both parties, I presume.
Please, my lord, largely that, but we may just point out some facts that substantiate the law arguments, but essentially it's arguments of law.
Please do that in your. If there's any clarification required, then the court may call upon the parties to do so.
Grateful, my lord. So 3 weeks, your lordship may give us.
Fine. That's only in 15.
That's in 15, my lord. The
my lord, all may come up together, my lord, after 3 weeks. Because 4 matters are more or less identical, my lord. Those are item number 14.
Okay,
item 14 is PBI's petition, my lord.
Let me pass an order in 15 then.
15 to 18, my lord. That's an identical order.
15 and?
15 to 18, my lord. 15, 16, 17, 18.
20?
15 till 18, my lord.
15 till 18, but Mr. Khurshid will not be in this all case.
But
you will be in
15.
15 and 16.
Please, my lords, please. Because my briefing counsel is also on screen.
Yes, she can.
Yeah, she will.
16 is yet to be argued, my lord. So this order would only confine to 15. All the matters may come up after 3 weeks together. We have no problem with that.
So 15 has no connection or relation with 16.
My lord, those are two different impugned orders. We are yet to argue 16. It's a completely different issue. Therefore, the written submissions would only confine to item 15.
Fine. Heard Mr. Salman Khurshid, the senior counsel, appearing for the petitioner, assisted by Ms. Sanchita, and also heard Dr. Musika, Leonard DSGI, appearing for these respondents, CBI.
Manoj, I'm sorry, because I have some junior counsel with me as well. I'll get Sanchita to put it in the chat box, Manoj, the names in the chat box. So
Okay, fine. Yes, you can give
As
many names as you want to give. We'll include.
there are only a couple more. Thank you.
Basically, you're spearheading the argument, so makes a difference.
Very kind. Thank you. Thanks very much.
The London Senior Counsel has, however, submitted that the oral argument has been advanced by both sides, but for sake of clarification, the same may be allowed to be presented in brief written form. Pray allow, let the written argument be filed within 3 weeks. List the matter accordingly. List the matter thereafter. List the matter after 3 weeks. So the other.
Others, my lord, in respect to 17 and 18, my lord, we are expecting that my learned senior will be arguing for Empirin. But since my learned senior has not argued and my lord will be filing the written argument, we will be having a little small summation, my lord.
I have not heard you.
Yes, my lord.
16,
it was heard. We had started the argument, my lord, but not concluded. Okay. So, if my lord may have any days, my lord, Thursday or Friday, my lord, we can conclude our argument. Thereafter, we can file the written argument, my lord.
1780, on pre-made by Mr. S. Panthi, letter counsel for the petitioner. This is matter after 1 week. So 14th,
14 and 16 can come together after 3 weeks.
14th on pre-made by Dr. Musika, letter DSGI, appearing for the petitioner, CBI. This is matter after 3 weeks.
Obliged.
Thank you.
Deeply obliged, fellows. Deeply obliged.
Deeply.